In this video, I want to go through and outline the main defenses to copyright infringement. One of the most important ones is the one that's actually contained in section 120, the infringement provision, subsection 2, which says that there will be no infringement of a trademark that is used in related goods or services where there is no likelihood of confusion. That also is applied in the section 120 sub 3 cases, so that if consumers are not likely to be confused by use of a mark unless the mark is used in the same goods or services, then no infringement will apply. In fact, even though the mark or a substantially identical or deceptively similar mark is being used. But the formal or explicit defenses, the biggest set of those are in section 122, and these are called the good faith defenses. So it's not an infringement of trademark, for example, to use your own name or the name of your own business in good faith. It's not an infringement of trademark to use a mark in order to describe the qualities of a good, the characteristics of goods or services, that is the kind, quality, quantity, so on, location, and so on and so on of a goods or services. So using a sign essentially descriptively rather than as a trademark. That has a little bit less room to play, because in that case it will often be the case that the respondent is not actually using the trademark as a trademark, but it provides some extra certainty for users of trademarks who want to use a mark in order to indicate the characteristics of the goods or services that they are selling. One of the most important defenses under section 122 is the comparative advertising and spare parts defense, so that traders can use registered trademarks to show that their goods or services are compatible with those of the registered trademark. So I can use the Apple iPod trademarks in order to market my goods that are compatible with Apple iPods, or market my Apple iPod repair services, or spare parts, or so on and so on. And that's important to ensure that trademarks don't provide registered trademark owners with an extensive monopoly over not just the particular signs that are used to describe or distinguish goods or services, but any other goods or services that happen to be compatible with or utilize those goods or services. So that's quite an important area of leeway for traders under the Trademark Act in section 122. Another exception that's really important for competition is the comparative advertising provision. So again, in section 122, it's permissible for traders to use other people's marks in order to distinguish their own goods or services from the competition. So you're saying that my brand of portable music players might be better than Apple's iPod brand of portable music players, for example. And that's allowed in order to help encourage competition and help traders engage in genuine comparative advertising between the two marks. For each of these defenses, the term good faith means, or has been interpreted to mean, the absence of ulterior motives. And that's Angoves and Johnson, the 1982 case. Another key defense is the consent defense, section 123, otherwise known as exhaustion. This applies where the sign has actually been applied by or with the consent of the trademark owner in relation to the goods or services in question. So in particular, this means that if I purchase goods that bear a trademark overseas and bring them into Australia, parallel import them into Australia to sell here, I don't infringe the mark because I'm using that trademark in the course of trade to distinguish those goods or services, because the trademark has been applied with consent of the copyright owner. And that's really important in order to enable parallel importation and also the second-hand market. All of these are traditionally things that people can do with respect to goods. The owners of goods are allowed to sell those goods. So trademark law this defense in trademark law ensures that trademark owners don't get to extend their monopoly impermissibly into, and it makes sure that they can't control secondary markets or parallel importation of their goods or services, or goods. And finally, the prior use defense in section 124 means that if a person was using a sign that is substantially identical or deceptively similar to the registered trademark, if they've been using it concurrently for a period at least before the priority date or the filing date of the trademark application. So remember that registering trademarks is not necessary. It is, you can use a sign to distinguish your goods or services without registering the trademark. But if you don't register the trademark, other people may be able to in some circumstances, and particularly if you neglect to object to the registration of the mark, other people might obtain registration for the same or a deceptively similar or substantially identical mark. If that happens, the defense of prior concurrent use applies, so that the person who's been using a mark continuously for a period for longer than the trademark was, or for a period that extends to before the date in which the registered trademark was filed, then that person can continue using the mark. There's some limitations to this. For example, if I'm trading under a particular name, but I've only been trading in Brisbane, I can keep using that name even after someone registers it in Australia, but maybe I can only keep using it in Brisbane. And if my reputation only extends to Brisbane, if I've only been continuously using the sign unregistered in Brisbane, then I won't be able to expand my business beyond Brisbane. Beyond the boundaries of which I've been historically using the mark. But otherwise, it provides protection for traders who have been honestly using a mark for a long period of time before, or even just any period of time before registration. Finally, just quickly on remedies. Remedies are pretty simple. As always with IP remedies, an injunction is often very important and it's available in any terms the court sees fit. And the applicant also has the entitlement to elect between damages if they have suffered harm, or an account of profits if the respondent who has infringed the trademark has been found to or can be shown to have been enriched by the use of the trademark in an infringing way. But that has to be at election. You can't get both damages or account of profits, of course. You must elect between one or the other.